Hi, welcome back to Securities Regulation. We are going over some of the basics of commercial and corporate law that you would have learnt of in past semesters. Now that we've covered contracts and property, it's now time to move on to a review of company law. Now, to understand company law, we must first understand the various forms of businesses, right? Now, what is the simplest form of a business? The simplest form of a business is where one person is simply carrying out the business by herself or himself. This is known as a sole proprietorship. Now, the sole proprietorship is owned typically by an individual only, not by multiple people. The liability of that individual is unlimited. One cannot cap his liability. And we'll come to what this limited liability and unlimited liability means. The management of the sole proprietorship is carried out by the owner himself, and there is no succession in the sole proprietorship. However, that is not to say that the assets owned by the sole proprietorship cannot be transferred through succession. The assets can be transferred through normal channels of succession, whether through a will or intestate. There are no forms required, there's no registration required for a sole proprietorship. One can start a sole proprietorship in the confines of one's home or a hostel room. And whatever profits that are gained out of a sole proprietorship go back to the individual. Since the individual is the only owner, the individual has the sole right over profits. This becomes slightly more complicated when you have a partnership. Now that's the next level of complexity when it comes to business transactions, when it comes to business ventures. Now, in a partnership, one or more individuals are involved, typically at least two. Now, here's the problem. When there are two people involved, both of them are liable not just for their own actions, but for the other person's actions as well. Now, we've learnt this in partnership law, where partners are jointly and severally liable for the actions of each other. What this means is, if one partner is carrying out an activity which then puts the partnership at jeopardy, the other partner, who was possibly not involved in that activity, would have to bear the liability as well. In other words, each partner is responsible for the actions of the other partner. Their liability is also unlimited, which means that there is no limitation on the liability that these partners would have to carry out. The management of the partnership is obviously left to the partners, that's self-evident. There is no succession in the partnership either. What this means is that every time a partner passes away and is replaced by another partner, a new partnership is formed. In terms of registration, partnerships are typically not registered. However, it is optional. Partnerships can register themselves. If they do so, the partnership will be able to carry out or institute legal proceedings in their own name. And of course, whatever profits are born out of the partnership is distributed between the partners in proportion of their involvement. There are a couple of other business venture structures known as limited liability partnerships or one-person companies. However, in India, these haven't really taken off. Effectively, a limited liability partnership is nothing but a partnership where the liability is capped. And again, we'll come back to this concept of limited liability and what it means for business owners and businesses later on in this module. A one-person company is pretty much the same as a partnership. It has limited liability, but there is only one person involved. You do not have multiple shareholders, you do not have multiple owners. Again, in the Indian context, the one-person company and the limited liability partnership have not really taken off. Now let's come to the plain vanilla private company. For a plain vanilla private company to exist, you'll need to have at least two shareholders. Now this can be taken up to 7 shareholders as well, right? You can have, of course, in excess of 7 shareholders, but we'll come to why that 7 shareholders is important. When you have a company, this is the first time we're coming across the idea of limited liability. What this means is that the liability of each of these owners of the company or shareholders of the company is limited to the extent of their shareholding. Again, we'll discuss what shareholding means. But suffice to say that individual owners of the company or individual shareholders, they are liable to the extent of money that they have given to the company or have promised to give to the company at a later date. Again, in a private company, the management of the company is left to a separate entity recognized under law as a board of directors. Now, English common law and therefore Indian law and, well, law all over the world recognizes that shareholders and the board of directors are two separate entities. While in India, it is not unusual to see majority shareholders also on the board of companies, they are treated separately under law. The private company is also treated as a separate legal entity, and therefore it is an entity that continues in succession. They say that a company is pretty much immortal, that shareholders may come and go, but a company is forever. In terms of its formation, a private company requires compulsory registration before the registrar of companies. A form will need to be drawn up, will need to be filled out and signed by the first shareholders of the company, also known as the promoters. We will need to draft charter documents, in the sense you will need to have the articles and memorandum of association and a number of supporting documents that allow the company to appoint directors and to carry out its day-to-day activities. In terms of its profits, the profits of a company when a dividend is declared are distributed amongst its shareholders. Now, we've seen what a private company looks like. What's the difference between a private and a public company? Now, this is a question that stumps many people. And there might be a number of differences that you might find in a textbook or in the Companies Act. However, the key differentiating element between a private and a public company is transferability of shares. Now, the idea that shares can be transferred forms one of the key principles of corporate law or company law. A private company, by definition, under Section 2 of the Companies Act, says that a private company is one where the share transferability is restricted. In other words, if you were the shareholder of a private company, you would not be able to transfer your shares without the approval of the board of directors. The reason for this is that private companies are designed to be closely held within a family or a group of people who trust each other. On the other hand, a public company is, well, open to the public, and anybody can come in and buy their shares, sell their shares as they see fit. This becomes the critical difference between a private and a public company, where share transferability is restricted in a private company. Share transferability cannot be restricted in a public company. All other aspects between a private and a public company in terms of its critical aspects remain pretty much the same. However, a public company will also need to have a minimum of 7 shareholders. So if I were to present a company to you having 8 shareholders, that could be a private company or a public company. The question you should be asking is that whether share transferability is restricted in the private company or is it not restricted, in which case it's going to be a public company.